My Lords, my Lady, good morning. My Lords, my Lady, it remains for me to address the two questions in my Lord the Master of the Royal's email 2 days ago, and I'll do that this morning. If I may, I'll also provide a number of points by way of conclusion to my overall submissions that I advanced yesterday. Now, my Lords, my Lady, rather than simply furnish your Lordships and your Ladyship with 114 pages of our closing submissions below, we compiled a note which is rather shorter, which seeks to extract from those submissions all the points relevant to the answer to the questions that were raised. And your Lordships and Ladyship have had that.
And Mr. Weeks had a copy, I assume.
I'm so sorry.
Have you provided a copy to the other side?
Oh, yes, of course,
yes.
at the same time.
We've got a copy. You say we've got that? Did you say you've given it to us?
Yeah, we had that the day before.
Oh, that one. Oh, I'm so sorry. Yes,
Yes.
I thought you were about a new document.
No, not a new document. This is the one called Respondent's Note
Yes,
to
no,
address
I've
the
got
additional points.
Yes,
And
yes.
I think your Lordship had mentioned having seen that yesterday.
Yes.
And my Lords, my Lady, I don't propose to go through the points that we set out there. They speak for themselves. Can I introduce them with this proposition? The second of the two questions that we were asked was whether it is right to apply Article 8 horizontally so as to extend the law of nuisance to overlooking. Now, my Lords, my Lady, that question is really premised upon the judge having found a breach of Article 8, because if he didn't, then there is no consideration that arises, because Section 6 of the Act will not be engaged. Now, the judge did not find that there had been a breach of Article 8. So, in my submission, this second question simply doesn't arise. What is left is the first question, whether as a matter of policy, the law of nuisance should be extended to overlooking, rather than simply leaving it to other aspects of the common law and statute. And it's that which I'd like to deal with now.
Sorry, are you saying the appellants say that if this claim would not otherwise be justiciable under the existing law, it should be capable of being extended under Article 8. So, in other words, that what otherwise would have been the law in the past should now be extended, not as a pure Article 8 claim, but I think as an extension of the otherwise existing cause of action. That's as I understand it.
Yes.
It's not a pure Article 8 claim, as I understand it.
No, but my Lord, the point I make is simply an anterior point. For the court to be engaged in this case with whether it's right to extend the common law of nuisance, it has first to be satisfied that there's been a breach of Article 8. If there isn't a breach of Article 8, Section 6 is simply not engaged. And we don't get to the position whereby the court considers whether to extend the law of nuisance. By reference to that act. My Lord, that still leaves open the question, is overlooking the type of harm which the law of nuisance should protect.
Regardless of Article 8.
Absolutely, my lady. Yes, and that's a separate question, but it's simply not an Article 8 question.
But is that the way round it works? Don't you have to say the state has an obligation to protect privacy from overlooking? Therefore, we extend the law of nuisance to cover overlooking as an additional form of encroachment onto a neighbour's land. And then we have to apply the law thus extended and find out whether there is a breach, whether there has been an actionable nuisance now having that extended scope. And I think what Mr. Weeks is saying is that on the facts as found by the judge, the answer to that is inevitably yes. But I'm not sure that you go round it the way that you've suggested.
I understand your ladyship's point. It's not the way I understand the way in which Article 8 works. One first considers, is Article 8 breached in this case? If so, then you bring into play Section 6, and that requires the court to open up the human rights considerations. But if one doesn't have an initial breach of Article 8, Section 6 isn't engaged, and one doesn't come to a human rights analysis. One simply stays with the question, is the law of nuisance capable of embracing this additional harm?
In other words, the obligation of the state is to have a law which does not allow somebody's Article 8 rights to be violated. And if Article 8 rights are not violated, on the facts of a particular case, then the state is not in breach of any obligation.
That's right, my lord. Yes. Now, your lordships and ladyship may say, well, that's all very well, but we're still left with the problem is overlooking, as in this case, something that should be protected against. But yes, and I grapple with that, but I don't do it through the prism of Article 8. I don't need to. I just have to look at whether the common law is something which embraces this. Now, that may be in effect the same question, but it's one which arises in a conventional way, which the common law is well
Can you
able
just
to
take
deal
us to that part of the judgment which deals with the fact you say he didn't find a breach of Article 8? Where does he deal with that issue?
Yes, it's, I think, tab 2 of the first file, I think it's around paragraph 100 and 212 degree. Sorry, 220 until. So the assessment that I've carried out, he says, this is page 62, is the usual one applicable to nuisance, even if privacy protection now arises via the application of Article 8. That article generally requires an assessment of whether the claimant has a reasonable expectation of privacy. In my view, an assessment of that nature would be almost identical to the balancing exercise. In this case, it would arrive at the same result. The sort of factors which mean that the claimants cannot claim that the use of the viewing gallery is a nuisance means that they don't have a reasonable expectation of privacy. If that is relevant, I need say no more about it than that. So he didn't go on to say, well, in this case, Article 8 is breached. He analysed it in conventional nuisance terms.
What happens if we were to find that he was wrong? What if we were to find that he was wrong in the way he approached, on conventional grounds, the issue of nuisance?
Well, my lord, that's not a question.
Well, that's the appeal. The appeal is that the judge was wrong in at least two respects in the way he approached the nuisance. One is in his treatment of particular sensitivity of the building, and the second is that he applied a kind of an overriding gloss of reasonableness over and above what I would describe as the traditional steps.
Yes.
And insofar as 220 reflects those matters, why is it not open to the appellant here to say, well, actually, there is an Article 8 extension point?
Well, my lord, it's not at the moment what they do say. It's not one of their grounds of appeal. If that's what they choose to say, then that's something I'll have to grapple with.
Well, it's up to, I think the long and short of it, Ms. Fairstone, it's up to you. If you don't want to address us on that issue at all, and simply leave it on the basis of paragraph 220, that's entirely a matter for you.
Yes.
I can't say more than that.
I don't take that approach, and indeed our extra note deals with both the questions.
That's what I think.
I merely wish to
Yes.
say, my lord, that there is an anterior point which arises in the way which I've addressed your lordships and ladyship to. But I don't say, and that's it, I needn't go on to consider question 2.
I see.
That would be
So I thought that's
rather
what you were
offensive.
saying.
Yes.
The judge's discussion of Article 8 is really paragraph 170 to 175.
Yes. Yes, my lord, and that's absolutely right. But even there, he leaves it in 175 on the basis that the consideration under Article 8 would involve consideration of whether there's a legitimate expectation of privacy in these circumstances. And the judge said, well, that's the same sort of exercise as I've been considering in this case. But it doesn't lead him to the conclusion that there has been a breach of Article 8, which then engages Section 6. But, my lords, I think I've said all that I need to say about
So
this.
I think the way I'm going to understand you deal with what I described as the second of the 2 points
Yes.
is your overriding point is there was no breach, no finding of a breach of Article 8, and therefore the question of any extension of the existing tort to accommodate Article 8 doesn't arise. But were that wrong, we have your written submissions.
That's absolutely right, my lord. Thank you.
And that's very clear. That's it.
Now, my lords, my lady, I'm not going to go through my note in any detail. Can I just show your lordships and your ladyship the way it's laid out, and then I'll make some supplementary submissions. So it has a number of headings as one reads through, and the first heading above paragraph 4 is private nuisance is not apt to be extended to protect general privacy rights. And it starts by referring to Lord Hope's judgment in Hunter, where he sets out in the passage underlined that the English approach as to nuisance is concerned essentially with the law of property. And he ends by saying the function of the tort in the context of private nuisance is to control the activities of the owner or occupier of property within the boundaries of his own land, which may harm the interests of the owner or occupier. So that's the conventional approach to the law of nuisance. We say simply that trying to pull that out of shape to extend to protect not merely owners and occupiers, but all others who may be engaged is not an appropriate thing to do with this particular tort. And I gave your lordships and ladyships some reasons supporting that yesterday, which I don't think I need repeat. There's just a straight mismatch between the private nuisance tort on the one hand and what is sought to be derived in this case, which is some sort of general freewheeling protection of privacy on the other. Now, so that's the first passage, those paragraphs from 4 to 8. And then in 9 to 13, we make the point that the law of nuisance does not protect every right that goes with property, right in inverted commas. It's not every facet of ownership of land which is protected by the tort. There are certain greatly significant things which have always been left out for reasons of public policy. So there's no right to a view. That would cause great damage in a crowded island. And there's no right not to be overlooked either. And the leading authority in support of that proposition is the Victoria Park Racing case in the High Court of Australia. And although the judge aligned himself with the dissenting minority, I commend to you, Lordships, what Chief Justice Latham says, which we record under paragraph 10. Any person is entitled to look over the plaintiff's fences and to see what goes on in the plaintiff's land. And in effect, I summarise colloquially, if the plaintiff doesn't like it, his remedy is to put up a higher fence. And there are obvious ramifications for this case. So you can, if you can protect yourself, that is your remedy. So there's no law against overlooking, there's no right to a view, and then the common law of private nuisance won't interfere on the grounds of invasion of privacy either, and that's what we say in paragraph 11, citing authority. And then in 13 to 19, we go on to develop that. The law of nuisance won't interfere on grounds of invasion of privacy. And I'll develop that in a little more detail in a moment. We next say in 20 to 24 that there are sound policy reasons for not extending the common law of nuisance, and I'll come back to that as well. And then we end by saying in paragraphs 25 to the end that privacy rights are better protected by other laws altogether. And if they are thought to be insufficient, then one looks to the legislature to improve the position. But we say there's no gap in the law at the moment. Now, so that's how our extra submissions work. Those are the brief headings and the guide to the content. Can I just add to those these following points? The cases where a claimant has succeeded in establishing nuisance, where there's not actually any emanation from the defendant's land, are vanishingly rare. But on top of that, not merely rare, but non-existent, are cases where mere overlooking has been held to be a nuisance. And the ones out of that mould which a court have held to be actionable are those listed in paragraph 34 of our closing submission, so the longer document which I believe your Lordships and Ladyship has.
Yes. Paragraph 34, page 34.
It's page 14 of those, page 34.
Yes.
So I'm dealing here in 34, page 14, with non-emanation cases. And I say that the reason for the court's avoidance of finding a cause of action in the case of non-emanation cases is because there's a need in nuisance cases to demonstrate harm to land in contrast to persons on the land. And then the first bullet point, in no case has a court decided that it's a nuisance for a defendant simply to stand on his property and watch the claimant's property. And then I go on to deal with the watching and besetting cases, and the bullet points that follow are all examples of where the watching has had to be accompanied by something more. So there's picketing, missionary activity with loud and insistent proselytizing, and then the Bernstein and Skyview's case of flying over a property taking photographs. But in that case, there was no nuisance. So, my lords, there simply are no examples in the decided cases of overlooking being held to be a nuisance, notwithstanding a number of attempts. So, I think that enables me to say that this case is an unpromising candidate for an extension of the law of nuisance to include overlooking, and not merely because of its rarity, but especially so for really because of the consideration of three extra ingredients, and those are planning controls, the facts of this case, and thirdly, the potentially alarming consequences for landowners and the courts, were your Lordships and Ladyship to allow this appeal. let me go through those three in turn, if I may. Dealing first with planning control. Now, the virtue of planning control is that planning authorities bring objectivity to bear in an area which is fraught with subjective emotion. Planners are more likely, with the benefit of their framework of rules and their experience in other cases, to respect the standpoint of the plain and sober person, which is the person that we are primarily concerned with in the law of nuisance. And over and above that, planners adopt a holistic overview of public amenity. Now, in this case, if the appellants are right, the planning system worked to the great disadvantage of the respondent in two particular ways. The first was by first imposing a planning condition on native land which required screening measures, and then not enforcing that condition, so allowing the developer to build without the measures which would have afforded substantial protection to these flats. And the second disadvantage to the respondent was that it was positively encouraged, not merely by the local authority, but by the 2016 London plan, to have an amenity open to the public on the top floor. That's something which has been part of the London plan, which planners are very, very keen on encouraging, public amenity. And we also know from the documents shown to the judge, in which he recites in his judgment, that not merely were the planners keen to have this public viewing amenity on the top of the building, they also were very keen to encourage that nothing should interrupt the view. And all of those considerations, my lords, my lady, prompted the Commission for Architecture and the Built Environment to comment at the planning stage that the viewing gallery had the potential to become one of London's great rooms, recorded in the judgment and taken from the joint statement, paragraph 45, and I can give you...
Have you got this is all in the judgment, is it?
I'm not sure that particular passage is, my lord. It's in the joint statement, which was before the judge. It's paragraph 45 of that, and the bundle reference is tab 32, page 314.
Or what, the supplementary one?
Of the supplementary bundle. And, my lords, my lady, I say, based upon those two propositions about the way in which, if the appellants are right, the planning system worked to the disadvantage of the respondent, that can't be right. It would be grotesquely unfair. So much for planning control. Now, what about the facts of this case? Well, can I just ask your lordships and ladyship to bear in mind, and these, of course, were all well within the mind of the judge, but won't necessarily have assumed any particular importance in the court's mind in this case, at this level of appeal, that all the flats were fitted with solar blinds in the winter garden. All of them. The judge saw the winter blinds in operation. He had them raised and lowered, and his comment, this is in paragraph 215 of the judgment, was that the blinds would give the appellants a good degree of privacy in daylight hours at the cost of their clear view of the outside world. Now, clear view of the outside world, one reminds oneself, is not a protected amenity. So, the solar blinds give a good degree of privacy in daylight hours. He went on to say that this would detract from the claimant's living conditions, but not to an unacceptable degree. So that was his value judgment, having visited the flats. Now, there I'm just dealing with the winter gardens, my lords, my lady. But it was the winter gardens which were at the absolute focus of the case, because they are the most visible part of the apartments. They thrust out from the flats. And through the winter gardens, one can then see the living space beyond. Now, it's unfortunate in this case that all the claimants have been using the winter gardens, designed effectively as indoor balconies, as simply a part and parcel of their living accommodation. But as the joint statement shows, that was not the intent from the outset.
I don't think it's 215, must be something.
214, my lord, and then 200.
214A.
214.
Where did the judge say that all winter gardens were fitted with solar blind? That's in the joint statement.
That's in the joint statement.
That's in the joint statement.
Yes. So that's the winter gardens. So you shouldn't mind being stared at there, because effectively it's like a balcony, but you have a remedy in the shape of your solar blinds if you don't like it. Now, as to the remainder of the living accommodation visible through the winter gardens, that could be screened to a large extent by a curtain across the divide, and of course such a curtain would not engage the covenant in the lease, because it's an internal divider. And we know that at least one of the claimants did have such a curtain. It's shown in the photograph, which I'll just take your lordships and ladyship very briefly to, in the supplemental bundle at tab 20, page 209. Tab 20, page 209. The photograph in the middle of the page, this is taken from the Daily Mail online in 2018. The curtain in question is stretched across diagonally from bottom left to top right. I hope your lordships and ladyship can see that. And that's the curtain which was originally there, according to a passage in the evidence, which isn't in the bundle, but about which there, I think, can be no dispute. The claimant in question, this is flat 1301, said that the curtain was on the divider between the winter garden and the flat when she bought the property in the first place as a show home. So that's how it was fitted out. So that would be a very good bar to the intrusive gaze from the outside world. Of course, this particular claimant has not helped herself by displaying right at the forefront of the winter gardens cardboard cutouts of Sir Nicholas Sirota, his daughter and his wife.
But it would make the living area dark then, wouldn't it? I mean, it would
My lady,
close off all the light coming from the outside into the winter garden.
My lady, it's a net curtain.
What's that one that we can see there?
Yes, it is. Yes, it is. It's made out of perforated fabric, so it wouldn't darken the remainder of the accommodation. At least the judge did not consider that to be a case to an unacceptable extent. So that is an example of a measure which was actually taken, had been taken, I think, by the developer in this show home to prevent the intrusive gaze beyond the winter garden into the interior. So that then leaves just the bits of the living accommodation which are on the eastern flank of these flats, the view into which is not gained from the winter gardens, but rather just through the flank windows. And my lady, we say that's simply a question for curtains. We don't like the part of the gaze that can come through there. Excuse me a minute. Yes, and of course, my lady, there are windows on both elevations, so even if your ladyship's point...
What's the difference between solar blinds and solar screening? And what is a solar blind? Is it something inherent in the glass itself, or is it?
Oh, my lady, no. I think they're both the same concept. It's a protective measure against too much sun coming in. So solar screening in this case was affected by blinds. So they protect against sunlight. They also protect
Is
against...
it just a roller blind?
Yes, my lady, in effect,
With a,
yes.
with a translucent materials.
Well, they're not translucent, my lady, no. They've got to keep the sun out.
But they're not as
well,
opaque as they would be if you were using them instead of nighttime curtains.
my lady, in daylight, they appear to be completely... they appear to form a complete barrier. The complaint the claimants were making is that at night time, when there are lights on inside, then that gives a fuzzy image of people inside. And one can see photographs in the bundle illustrating that. So,
If we look at page 168 of the supplementary fund, we've got a photograph on one side of the clock.
yes,
Some people seem to have some sort of white line, and some people have a grey line.
and one person, the third flat down from the top, appears to have a net curtain. So yes, all the black blinds that one can see, which are on the winter gardens, are, I think, the solar blinds. So in daytime, they offer a complete barrier to the view. And most people, it seems, have some of them fully deployed or partly deployed. And then to the left, one has the light brown structures, which are the louvers, which are a solid structural component. And then also, as your lordship points out, white blinds, which are some other sort of blind altogether, which also prevent the inward view. So a variety of treatments used by the occupants to screen their premises, and some of whom don't bother at all. Now, to meet my lady's point about darkness, if there is an internal screen across the divider between the winter gardens and the remainder of the accommodation, of course, one has light coming in from the western elevation, which one can't see on this particular photograph. So it's never going to be too dim. And the judge, of course, saw that in operation with blinds going up and down in various flats. So, and the passage where the judge deals with the solar blinds in his review of the evidence is in paragraph 8 of the judgment on page 11. He says between D and E, sorry, this is page 11.
Yes.
The flats all have solar blinds which would obscure views of the interior, though not very effectively at night when lights are on inside the flats. But to keep those down would obscure the views which the occupants consider to be one of the key advantages to the flats, and would involve their living without the benefits of windows along one complete side of their living accommodation. And of course that was the crux of the case. The claimants were saying, I want my right to a view preserved, please. I don't want to have it obscured by blinds. And then the judge, so that's in paragraph 8. Paragraph on page 29, the judge adds to that. Judge adds to that by page 29, paragraph 87. Just below the first hole punch, subparagraph J, he says, when lowered, the blinds that I saw in one of the flats, which I assume was typical, reduced the light somewhat but not oppressively. The nature of the blinds was such as to allow a fuzzy view of the outside world through them. They were not and were not intended to be totally opaque. But in the photographs which the court has seen, they pretty much form during daylight hours an insurmountable barrier. And the last passage in the judgment on this topic is on page 60, paragraph 214, where the judge deals with the remedial steps that could be taken. And the first category he turns to is the solar blinds. The owners could lower their solar blinds. That would give them a good degree of privacy in daylight hours at the cost of their clear view of the outside world and a certain amount of light, and so on. So, for 7.5 hours each day when the gallery is open, there is a view potentially into the flats, that there are measures which can be taken. And then my last point on the facts, my lords, my lady, is just to point to remind your lordships and ladyship of a matter which was to the fore at the hearing, which was the sheer amenity offered by the viewing gallery. An enormous success for the Tate, an undoubted public benefit, the presence of which has no doubt lifted the area as a whole. That's to be set on one side, compared to what the judge held to be an acceptable diminution in amenity for the 5 claimants, a tiny minority of surrounding inhabitants, who would have to put up with a fuzzy view of the outside world instead of a clear view for 7.5 hours a day.
Now, right, so what's all this got to do with justiciability?
My Lord, it really goes to the point raised by, I think, by Lord Justice Lewison yesterday, balking at the use of the word reasonable in the nuisance cases and suggesting instead that justifiable might be a better descriptor. And thinking about that overnight, my lords, my lady, perhaps another acceptable descriptor would be legitimate. It is relevant, I say, not to ask the difficult question, is the use of the viewing gallery necessary? Because in many senses it is. It's the only thing you could use the viewing gallery for. If you ask instead the question, is it legitimate? And the answer to that is yes. That should then bring into play the balancing exercise, which I've been emphasizing in this case, is the right approach to carry out, and not simply to consider the impact on the flats. And within the confines of the law of nuisance, my lord, my lady, it's not necessary to go any further than that. That should be the permissible exercise.
I certainly see that in the context of what you were saying yesterday. So I thought, maybe I'm mistaken, I thought you were currently doing justiciability.
Well,
have you moved on to do with, because you did say you were going to supplement your comments yesterday.
my lord, this is by way of my summary of the points I was making yesterday. So, my lords, I said at the outset that I had 3 considerations for your lordships. One was to do with planning control, secondly the facts. The third consideration was the potentially alarming consequences for landowners and the courts if the appeal is allowed.
Yes.
And my lords, my lady, consider this. Disputes between neighbours are toxic enough as it is. Many of them reach the Court of Appeal, and many a judge in this court has voiced exasperation at the cost of arguing over 6 inches of land. It's a well-known phenomenon in this country. So that's bad enough. Hours and days, weeks of court's time is wasted in cases like that. If overlooking is added as a potential part of the cause of action, then in my submission there would be havoc. If my learned friend is right, then, and the only question to consider is whether the interference is necessary and convenient, then there will be alarming repercussions. And in my submission, the court is simply not the most appropriate forum to consider those repercussions. It will be complicated and expensive. It won't do anything for the public good. The alternative is the planning process, which has a perfectly capable system for analysing these issues and deciding whether or not buildings are too close, whether a roof terrace should be allowed, and all that sort of thing.
Can you just go back a bit, because there's a bit in your earlier submissions that I didn't fully understand. I noted it. You said that planning control introduced an element of objectivity in an area which is fraught with subjective emotion. I still understand that. And then you went on to say that if the appellants are right, the planning would have been to your disadvantage of your client. If I mistake, and you mentioned two matters. One about the planning condition for privacy measures, and the other one was about the London plan and the amenity of the top floor. I'm not quite sure that I've fully taken on the point you were seeking to make there. I want to make sure I've got it.
Yes. Yeah. Well, the point is this. The defendant in this case, the Tate Gallery, went ahead in good faith on the basis of planning permission incorporating features which had the support of everybody that it consulted, including the Commission for Architecture and the Built Environment, the Planning Authority, the City Corporation, Native Land, the adjoining developer, with whom it was in close contact throughout the planning process. Effectively, although the Native Land development may have been finished earlier, the two planning processes were proceeding pretty much in tandem. So at the time, the Tate Modern extension with its viewing gallery was being proceeded with in good faith on the basis that it would be an amenity which would be encouraged by everybody and very much wanted. So in that sense, if the appeal succeeds, the respondent will have been disadvantaged.
What was the point about the planning conditions with the privacy measures?
Well, there again, my lord, if the planners had done what we submitted below they should have done, and said, well, it's all very well you coming to try and discharge your planning condition, but you're not sticking to the letter of the condition which you yourselves came up with involving these privacy conditions, then we would have been confronted not by walls of glass, but by some glass, but many more louvers, and it would have been very much more.
A condition of the permission, was it?
Was that right?
Yes, it was.
It wasn't. It wasn't.
Well, it wasn't as part of the description.
I thought that had been
Yeah,
dropped.
it wasn't a condition of the permission. It was a condition of the permission that the facade receive approval from the local planning authority. And when that permission was sought, the louvres on the outside of the building were removed. So my learned friend keeps saying
It's just a reserved matter.
exactly. And that condition was imposed not because of anything to do with privacy, but solely in order for the local authority to be able to regulate the appearance of the building. My lords and my lady, this all appears in the judgment, and when I stand up in a moment,
I thought there was something about
take-
this, that
take you
the
to the
original
passages.
messages were in the planning condition, but somehow disappeared from it. Anyway, yes, anyway, that's a contested matter.
Yes.
All right.
So, and was my lady going back to where I was?
Yes,
I'd finished that topic, the potentially alarming consequences for
Yes.
landowners in the courts. Can I then turn to my last point, which goes to the relevance of planning commissions generally. Now, I've learned a friend yesterday, towards the end of his submissions, cited extensively from Coventry and Lawrence
Yes.
to show that the existence of a planning commission for an offending activity is not a defence to a nuisance claim. We accept that, of course we do. We never argue to the contrary. But the point that we make in paragraph 20 onwards of our extra note is that the planning system affords a far more appropriate form of control than enlarging the right to bring actions in nuisance. And that is something which does have the support of Lord Carnworth in paragraph 218 of Coventry, which is what we did cite Coventry for, and we set out the relevant passage in our extra submissions. But it also has the direct support of Lord Hoffman in Hunter, and we cite that as well in our submissions, but perhaps I can just take your lordships and ladyship to the passage in question, because it is bang on point. It starts in paragraph 21 that the quote...
What's the tab number?
I'm sorry, it's in the respondent's note.
Oh, it's in the notes. Yes. Which para?
Paragraph 21 is where we introduce the quotation. And then we refer to Lord Hoffman, and the quotation is on the top of the next page. In a case such as this, where a development is likely to have an impact upon many people over a large area, the planning system is, I think, a far more appropriate form of control from the point of view of both the developer and the public than enlarging the right to bring actions for nuisance of common law. And then the last four lines, when your lordships are invited to develop the common law by creating a new right of action against an owner who erects a building on his land, it is relevant to take into account the existence of other methods by which the interests of the locality can be protected. My lord, those are my submissions, unless I can be of any further assistance.
I think we
No,
ought to
I'm
do
sorry,
that.
I'm getting calls from well, would your lordships excuse me? My lord, it's just this. The anterior point, which I'm not sure found particular favour with the court, which I started with this morning, is something that's to say one doesn't get to look at. The second question raised by my lord is one that has the support of Lord Hoffman in Wainwright. And can I just leave your lordships and ladyship with the short passage? It's in the additional bundle of authorities that was handed up yesterday. It's paragraph 32 of Wainwright. The lordships would like to look at it.
Yes.
It's tab 8 of this supplemental bundle. Page 423 of the judgment. Paragraph 32, Lord Hoffman says, and it's only the first half of the paragraph I need read, he says, nor is there anything in the jurisprudence of the European Court of Human Rights which suggests that the adoption of some high-level principle of privacy is necessary to comply with Article 8 of the Convention. The European Court is concerned only with whether English law provides an adequate remedy in a specific case in which it considers that there has been an invasion of privacy contrary to Article 8 and not justifiable under Article 8.2.
So how does that work then? So you would say what the court has to do is decide whether there has been a breach of Article 8 here,
Yes.
ignoring the law of nuisance for the moment, just applying the general principles laid down by the court as to when Article 8 is infringed. The court then finds that there has been an infringement, say. So what then do? Do you then have to go through an exercise of working out whether, well, if there is an infringement, is this also a nuisance but applying what test for it being a nuisance?
Well, my lady,
I don't understand
yes,
how
well,
the structure would
it's a
work.
good question, my lady. As I understand the law, the court is then required to find a remedy of some sort, having gone through the Article 8 safeguards. But if it doesn't, and then the remedy is a matter for it, may choose various different ways of addressing it. But the point I was making is that the court is not required by Section 6 of the Human Rights Act to do anything at all unless it first finds that there has been a breach of Article 8. It simply doesn't engage with the process. So one is left with the common law.
You said there's no appeal against the judge's final motion.
No.
Article 6.
Article 8, no.
Very well.
I must say, I don't really understand how that would work.
Well, I thank you very much indeed, Professor Hall. But there's, I think, one question we have to ask at the end. We have decided, because we thought it extremely important as a precedent-setting court on this important case, to go into these questions, which were raised before the judge, on justiciability. You have not put in a respondent's notice.
My Lord, no.
So we have to try to work, and of course, as Mr. Weeks rightly says, we can decide, we can hear whatever we want.
Yes.
What is the position in relation to the respondent's notice?
Well,
I mean, we have debated the issues.
yes.
Is your position still, you do not wish these matters to be raised?
My Lord, no, it's not. And, my Lord, we will, if this is something that the court is prepared to entertain, we will put in a respondent's notice later today.
Well, I mean, I think we will deal with the matters in any event, because we think they're important. They have been debated. We've given you time to deal with them. Neither of you has said you haven't got enough time to deal with them. But I think it would, we'll hear Mr. Weeks on it if he's got some technical objection, but I think that it would be tidier
Yes.
if you put in a respondent's notice in relation to both issues.
Yes.
But if Mr. Weeks objects, we'll see. We'll just have to decide possibly without the respondent's notice.
Yes.
We'll see what Mr. Weeks says.
Well, my Lord, I'm much obliged for the court's leniency, and I do apologise for not having sparked off and done that 2 days ago, when it might have been better to do so. I'm very much obliged.
Thank you very much indeed. Yes, Mr. Weeks. Shall we deal with the technical point, the last point? I mean, we've heard the case. Whether there's a respondent's notice or not, we think is extremely important. This is a very important case, and it raises these issues. However we decide them, we think they should be addressed by us. It would be tidier, it seems to me, if we had a respondent's notice. The judgment can explain the circumstances that we asked for the matter to be debated. But do you have an objection to that?
We, as I think indicated yesterday, we do not object to the Court of Appeal revisiting how the judge dealt with that issue, whether or not there is a cross appeal. However, we would say that, I mean, normally on an appeal, if part of the judge's ruling on the law by a first instance judge is an issue, you do have some sort of critique of it for a respondent to respond to. And so we have, the very careful, lengthy reasoning of the judge on that issue. And we don't have anything like grounds of appeal or skeleton argument providing any sort of criticism of the conclusion or the legal reasoning leading to that conclusion.
I understand the appellant simply, the respondent simply relies upon effectively its closing submission.
But I mean, normally that's kind of water under the bridge. That was the submissions made in the first instance. We now have a judgment, and we don't have any sort of worked up criticisms of that judgment to address. And the email we received from your clerk was obviously quite short. So all I would say about this is that because of how this issue has been raised by the court, we are at a bit of a disadvantage, and we are therefore keen to ensure that the submissions that we make on this, this obviously is an important issue, that we're keen to ensure that our submissions on this issue do address any particular thoughts that the court might have about the judge's reasoning, the particular reasoning. And so I'd be grateful if at the end of my submissions you indicate if there is anything that the court has in mind about the particular chain of reasoning of the judge that we need to address, that we haven't addressed.
Well, we'll do that in the course of your closing submissions. That's a perfectly fair, it's a perfectly fair observation to make. But at the moment, it seems to me it would be sensible, since we have heard the issue, since we accept that we can adjudicate on it, there should be a respondent's notice, albeit it's very late, but just it completes the paperwork. That's as I see it at the moment. I'm not sure you're really objecting to that. You're really saying
I mean, we don't care if there's a respondent's notice
Doesn't really make
or
any
not.
difference.
We just want to make sure if there's some particular point that the court has in mind.
I think the matters you have to
we-
very well. I think the matters that you have to address, that you sought to address, I think in your the lengthy closing submissions below, are that the judge was. The first thing is that there's been no case which has specifically and clearly said that there's a cause of action for overlooking. You have to face that fact. That's the first point that I think you need to address. And so there would be, and I think you accepted this, that there would be, in that sense, an extension of the law. I mean, there are, you may say there are analogous situations, and some of the, for example, a couple of the cases that are referred to by the judge or by your side have been those cases where, at an interlocutory stage, it's been found arguable that activities which are offensive to the site, prostitutes on the adjoining land, signs advertising pornography or pornographic may be obtained, sex shops, that those at an interlocutory stage have been found to be sufficiently arguable for an interlocutory injunction. Subject to those, there's been no case. The judge sought to distinguish, or rather to call it, sought to distinguish the cases where it has been held there's no cause of action for overlooking by a window. And the question, therefore, there is whether that they can be appropriately distinguished. And then there's a question of policy, isn't there, which Mr. Featherstone Hall's been addressing this morning, and both of you have addressed, I think, in your submissions, which is whether, as a matter of policy, it's appropriate for the court to extend the cause of action to include overlooking in circumstances where today we have planning controls, we have other developments mentioned in the cases, such as the law relating to harassment, confidential information, data protection. So there are these other things, and whether the court should develop those matters rather than Parliament, if there's a shortfall. I mean, those seem to me to be the main, and then there are all the Article 8 points. You have to respond to Mr. Featherstone Hall on that. He says you don't even get to Article 8, but if you do get to Article 8, the questions there will be, well, there's never been, as far as I'm aware, any case, nobody cited a case, where Strasbourg has said that overlooking is a breach of Article 8. That may not matter. Then we do know there's a very wide margin of appreciation, which is granted to a member state, and the question is, should it be for the court to take that measure of appreciation in any particular way, bearing in mind the court that the legislature has intervened in this area through harassment, so on and so forth. So I think those are the kinds of, and then finally a matter that was referred to, I think, again in Article 8, which is if you have an overlay, if you were to have an overlay of Article 8, if you get there at all, which Ms. Featherstone Hall says you don't, but if you ever got there, there's the question about whether the overlay of Article 8 would have other ramifications for the law of nuisance. One we've looked at was, under the present law of nuisance, for example, children and other licensees have no cause of action, but under Article 8 whether otherwise a cause of action for that might extend to them as well. So I think those, it seemed to me, that those other people on the bench with me can elaborate, but those seem to me to be the main items that you probably need to address. You can do those main ones. Those, I think there's agreement here, those seem to us to be, I'm not saying on any of those issues that the respondents would win, but you asked me, and I mean very candidly and fairly, and I'm responding in the same spirit, with those matters which I think are relevant.
Yeah, that's been extremely helpful. I'll endeavour to deal with all of those points. Before I start my response to what my learned friend said, we said to you, my lord, yesterday that we would provide the court the reference to in the practitioner book, to the Balham dentist case,
Yes, thank you.
referred to by Professor Winfield
Yes.
in his article.
Yes,
We have found that.
Thank you, very helpful.
It is not especially revealing, as I did remember. If I could. So it's a 1926 practitioner book. So obviously quite a lot of water has passed under the bridge since then. The footnote is at page 367 and it's right at the foot of the page. It's actually an editor's note right at the foot of the page.
Yes.
That's it, is it? Just that one sentence?
It is. So in answer to the question my lord the Master Rolls asked yesterday, there's not even we're not even told what the case is called.
Yeah. Don't know now. Help you.
Well, my lords, my lady, I think I have 11 points. My first point is that when considering the cases cited by my learned friend, the court should keep in mind that compared to our sort of case, in which someone is using their land in a way that interferes with a neighbour's occupation, the law adopts a quite different approach when considering a landowner's duties when confronted with a natural or man-made hazard. And if there is a helpful one-line summary of the principles in the Japanese knotweed case at Divider 27 in my Lord Constable judgment at page 614. Lines from the foot of the page, an occupier will also be liable if he or she fails to act with reasonable prudence to remove a hazard, whether natural or man-made, on their land.
Where are you, Miss Rees?
It's paragraph 44.
44, so I thought it was at page 617.
So 3 lines from the foot of that, of page 614. Occupier will also be liable if he or she fails to act with reasonable prudence to remove a hazard, whether natural or man-made, on their land, of which he or she was aware and where it was foreseeable that there would be a risk of damage. So there's a reference to the Goldman Hargreave case about the tree being struck by lightning, and I think Leakey was a landslip case. And your lordships and ladyship will no doubt be aware there's been quite a considerable development of that law on. It's been the landowner's duties are referred to as a measured duty. So we therefore need to treat with a degree of caution, first of all, Sledley, Denfield and O'Callaghan, which if you remember was the case about the trespasser who failed properly to install the grill on the culvert. That's a case of a man-made hazard. Also, it means we need to treat with a degree of caution Network Rail and Morris, which, if I could take you back to, is at Divider 20 of the Bundle of Authorities. So if we could look at the judgment of the Master of the Rolls at page 870.
Which was the tab?
This is, sorry, tab 20.
Yes.
So on the face of it, this case looked quite helpful to us because it suggested that there isn't even still a principle about abnormally sensitive uses of land. But I need to point out that the reasoning for that, as you'll see at page 870, paragraph 31, Lord Justice Buxton quotes from what Lord Cook said in the Delaware Mansions case. Now that was a case, it's a tree root case, so it's a natural hazard case. And there, he can, in the passage from Lord Cook says that the test is directed to what a reasonable person in the shoes of the defendant would have done. And the Court of Appeal said because that's the test, we can then just subsume the rule about abnormal, these sensitive uses of land into that test. The problem is that's the test that applies to dealing with hazards on land. It's not the test that should have been felt to be applied in Network Rail and Morris, and also in our case, where you're dealing with someone's use of land interfering with a neighbour. Also, these comments were obiter. And there is no consideration in the judgment of the relationship between the principle about abnormally sensitive uses of land and the fact that nuisances are taught to land. As I said yesterday, it's the justification for the rule. My second point is, if I could preface my second point by saying that as I submitted yesterday, there is no scope for any principle about abnormally sensitive buildings even to get off the ground in our case, because there is no reasoning in the judgment capable of supporting the view that when compared to homes generally, taking into account the neo-bankside flats location as well as the size of the windows and design, that the neo-bankside flats are abnormally sensitive to invasions of privacy. So that's what I said yesterday. But having said that, we agree with what my Lord, the Master of the Rolls, said in conversation with my learned friend about the powerful reasons for saying that the principles concerning abnormally sensitive people and abnormally sensitive uses should not apply to abnormally sensitive buildings. Now, as we understood your Lordship, first of all, you thought there was a difficulty in giving practical meaning to the idea of an abnormally sensitive building. And that was something that the judge referred to in Hoare and McAlpine in his penultimate paragraph. And yesterday, your Lordship said it was difficult to give any practical meaning, even to the idea of what an abnormally big window is in the locality. And just in passing, I mention the fact that my learned friend is wrong to say that the only other residential building in the locality with floor-to-ceiling windows is One Blackfriars. There's at least two more in the close vicinity of near Bankside, including Bankside Lofts, which you may or may not know. It's quite a distinctive cylindrical-looking building. The non-glazed parts are kind of burnished orange.
But do you say the principle doesn't apply to abnormally sensitive buildings because you can't identify such a building?
There are three reasons for that,
Right.
all of which we thought were touched upon by my learned friend, the Master Rose. The first one is the difficulty of giving practical meaning to the idea of an abnormal sensitive building. The second reason is, and I think my Lordship did also touch on this, that I mentioned it a moment ago, the justification for the principles concerning abnormally sensitive people and uses does not apply to buildings. The justification for those principles is that nuisances are taught to land, so you need to figure out what the sort of objective effect on the amenity of the land is, so you should ignore especially sensitive people and uses. But in contrast, a building is the land. It's part and parcel of the land.
So if somebody chooses to live in a Japanese style house with walls made of paper, they are entitled to complain about noise where somebody who lived in a brick built house wouldn't.
Well, I mean that is the paper house is an extreme, a very extreme example. I understand why you give, but that is a very extreme.
I mean, you might say that's all very well in Japan, but not perhaps next to the Globe Theatre. I mean, the locality, it seems to me part of your case is that when you're looking at buildings and what's normal or abnormal, you're looking at the locality.
Yeah.
And there are certain types of building which are to be expected to be seen there, and there are certain that are not. This is, I understand your submission.
Yes.
And you're saying, well, it's not unexpected to find this building in this location. You mentioned there are at least two others.
Well, that's right.
I
But
don't know that you'd be expected to find sort of Japanese paper building.
But to answer that extreme case, we would say that we would say there is no sort of principle of abnormally sensitive buildings to be applied in that case. I mean, the paper house is a bit difficult to. It's difficult to even imagine a paper house. I think. I mean, my third point, if this helps to answer it, we think there's much to be said for the way we think my Lord the Master Rolls put it yesterday, that when it comes to the building that the claimant chooses to occupy, the perpetrator of a nuisance should take the victim as he finds him. And that the governing principle is that you can't use your property in a way that substantially interferes with your neighbour's occupation of his land, irrespective of the type of building that he has chosen to occupy. We don't see that as a
I think you have to add consistent with the locality.
consistent.
You always have to add that, because all the cases emphasise that what may be appropriate in one location may not be
But
appropriate in another.
there is no case which has applied the abnormal sensitivity principles to buildings.
No, I know. Sorry, I'm just taking your last point that you have to find. You talked about the victim. Actually, I think it's that you have to take the property as you find it,
Yes.
and that depends on the locality.
Yeah.
I mean, the same point's made on the other side, of course, by the Tate, which says, well, they're occupying a building with a gallery, which is totally consistent with everything they're doing. But anyway, that point, I think, is a kind of a mutual point in a way.
And all attempts to date to apply those principles to buildings have failed.
Right. That's your second point?
That's my second point.
Yes.
My third point is response to what Miss McColgan said yesterday. We felt she rather mischaracterised our argument about Article 8 and sensitivity. We didn't say that. Don't say that under Article 8 a defendant can never rely upon a sensitivity to a privacy invasion created by the claimant himself. Obviously that's not right. If a celebrity has courted publicity suggesting they have a happy family life, the celebrity may be prevented from complaining about the publication of stories about marital strife. All we were saying was that the approach adopted by the judge in this case is inconsistent with the Article 8 case law, because in this case the judge thought that it automatically followed from the fact that a sensitivity to an interference by overlooking had been created in some way by the claimant, that the claimant was precluded from relying upon that sensitivity. And that principle makes no sense, as is illustrated by the examples that I gave, but also by the example of Princess Caroline's self-induced sensitivity by choosing to eat in a restaurant rather than choosing to stay at home. My fourth point relates to my learned friend's reliance on the first instance decision in the New Zealand case of Bank of New Zealand at Greenwood. And if you recall, in that case, the judge thought that a claimant's ability in a nuisance case to take steps to mitigate the interference falls to be taken into account as part of an assessment of the impact of the interference on the claimant. And we say that does not reflect the law, at least in this jurisdiction. The law is correctly set out in the Court of Appeal case in Miller and Jackson, and in the first instance Scottish case of Webster and Lord Advocate. And the principle is that faced with a nuisance from neighbouring land, a claimant is not required to remedy the nuisance by departing from the ordinary and natural way in which he would occupy his property. So when assessing whether there is a nuisance, the court disregards ways in which the claimant could mitigate the nuisance by departing from the ordinary and natural way of occupying the property. So in our case, the court, when determining whether the Tate is committing a nuisance, should not base its assessment on the assumption that the claimants act in a way that no occupiers of their flats would want to, which is that during the day they would keep blinds and curtains shut. Being able to open blinds and curtains during daylight hours is regarded as an important aspect, a natural and important aspect to the occupation of a residential home. I'm sure it's one of the first things all of us do first thing in the morning. We draw the curtains and adjust any blinds to allow light in. My learned friend says that we are therefore relying on a right to a view. No, that's not right. It is correct that under English law you can't establish a nuisance by establishing that a building has obstructed a view. That's part and parcel of the law. You can't establish a nuisance by relying on the existence of a building. Also, you can't acquire a prescriptive easement to a view. But under English law, a loss of a view is taken into account in other contexts. I mean, you could have a restricted covenant protecting a view, and there's no prohibition on the court ever having regard to views. And so, for instance, in a planning context, as part of the balancing of the public interest, it would be open to a planning decision maker to have regard to a loss of a view. But in this case, we're not the closing off of curtains and blinds. It's not just about the view or outlook. It's probably better thought of as outlook. It's obviously also about light and just the ability to look out of the windows. Finally, on Bank of New Zealand Greenwood, we do say, however, that the judge was right in the way he treated the fact that the bank, affected by the glare from the neighbouring building, had floor-to-ceiling windows. I didn't even take you to it, but it's at page 5. He didn't seem to think that was of any significance, and he certainly didn't determine the bank's case on the counterfactual assumption that the bank had smaller windows. I think I'm at my 6th point. You...
I missed the 5th in that case.
Right. Actually, I'm...
New Zealand was the 4th.
Right, I'm at my 5th.
Oh, I thought the right to the view was the 5th.
My next point is... I renumbered my points so many times, I'm losing track of them. But my next point is that my learned friend took you to, it's a small point, took you to took you to the term of a lease. The lease is constraining the ability to use blinds and curtains. And he also took you to an email from the landlord or its agent saying something about its current approach to blinds. I just make the obvious point, that does not stop the landlord changing its mind. It says nothing about the stance that will be adopted by a successor in title.
How does that bear on the question of nuisance? Surely that question of nuisance can't be governed by private contract, can it, between landlord and tenant?
No, I mean, you would first of all have to find against me in what I say about the fact that the claimants are not required to adopt unnatural screening. And the terms of the lease only becomes relevant if you thought that the claimants are required to adopt forms of unnatural screening, and then you'd look at perhaps at the...
How does this work? Let us suppose the judge's reasoning is right. He says, well, in practical terms, what you could do is you could lower the blinds, and if you were, or cover the windows with some other treatment, and if you did do that, then there wouldn't be a problem. Can you say, in answer to a claim in tort, well, we ourselves can't do that because the lease we have entered into with our landlord precludes it?
That's right. I see there does seem to be a problem with that. I wouldn't be an answer to say, well, you couldn't found your claim of nuisance by starting off by contracting out your right to take those measures. And there's also the principle that generally speaking, perhaps doesn't seem right that the rights in respect of the Tate could be affected by a private contract with a third party.
But it's not even a third party, is it? It's actually the owner of the land.
Yes, yeah. Yeah, the contractual relationships between the freehold and the leaseholders. I can see force in the view, perhaps they don't fall to be taken into account. This is obviously a small point, but I think I'd respond by saying I can see the force in what you say.
But you can't contract out of the ability to take measures to prevent someone else being liable to you in nuisance.
Yeah, there's a sort of general principle that in relation to your legal relationship with a third.
Well, if Neo Bankside, or whatever that company's called, was in occupation, and there weren't any leases, and it was possible to avert the gaze by lowering the blinds, then if the judge's reasoning is right, the freeholder would do it. It can't become a nuisance because of the terms on which the freeholder chooses to let the flats to somebody else.
Yeah, I as I said, I think there's much be. I can see the force in that. My next point relates to what my Lady Justice Rose said to my learned friend about Baron Bramwell's rule of give and take. So you'll recall that the rule covers those acts necessary for the common and ordinary use and occupation of the land. And in relation to some comments by my lady, I would just say that in that context, necessary does not refer to a kind of strict necessity. So it's not referring to stuff that you absolutely have to do, you're compelled to do, if you're occupying the land in a particular way. The sorts of things that fall within the rule.
Well, in Southwark Mills, Lord Hoffman gave the example of having a washing machine.
Exactly. This is, I've just.
Perfectly all right to have a washing machine.
I'm just.
Don't put it up against the parcel.
I'm just turning to, and in fact, I think probably different. He said that the tenants can hear not only the neighbours' televisions and their babies crying, but they're coming and going, they're cooking, cleaning, quarrels, and their lovemaking. So it's all that sort of stuff that falls within the principle.
This is Lord Hoffman in which case?
It's Southwark Mills at page 7.
But I think he deals with the give and take principle in his example of washing machines and televisions.
Yes, that's right.
It might be right to have it in the flat, but you may have to be careful about where in the flat.
Absolutely, that's a very good illustration.
I don't think the point that I was making was really directed at the degree of necessity. It was more directed at if you build something on your land which has a particular use, like a swimming pool or a viewing gallery or something, then you change what might be thought to be necessary for you to ordinarily occupy your land, because now you've built something else which, in order to use, you have to undertake a different activity.
Yes.
So at what stage is the necessity, or is the nature of the activity which is necessary for the common use of the land, at which stage is that assessed, or does it expand as you, I mean, you know, take an extreme example, if you build a helicopter pad in your garden, then the ordinary use of a helicopter pad is to have helicopters coming and landing.
Well,
but does that then mean it's a necessary use of your land to have helicopters?
I mean, leading up to that, I would, to answering that question, when Baron Brown was talking about necessary for the ordinary use of land, he's just talking about things that are sort of part and parcel of the ordinary use of the property. So in our case, if you think about the Tate's extension, I don't think you should be focusing solely on the viewing platform, but you'd say you'd be asking yourself, what is just part and parcel of the ordinary use by an art gallery of an extension? And that would include a members area, a restaurant, a shop, and galleries, and so on. But it wouldn't obviously include a viewing platform. Now, taking the extreme example, that my lady gave of a structure that is just a viewing platform. So imagine if instead of the Tate being there, there was a landowner that had only built a viewing platform. Perhaps it is right to say that sort of viewing from the viewing platform would be part and parcel of the ordinary use of that structure, but it would not be permitted to allow viewing from that structure into my client's flats. That wouldn't be using, in the words of Baron Bramwell, it wouldn't be use that is conveniently done. It would not be use that shows proper and reasonable consideration for the neighbours. So in that extreme example, the viewing platform would have to be adopt, for instance, screening to prevent viewing into the client's flats.
So it would be necessary in your view, but it would have to be moderated because of the conveniently
It
done.
is certainly arguable.
part
It's
of the
obviously
test.
not our case, but it may well be said to be necessary for the use of the viewing platform. But you wouldn't be able to allow viewing directed at the flats. That wouldn't be showing, as part of the give and take, that wouldn't be showing proper and reasonable consideration of the claimants. And just as a sort of further extension of thinking about how that principle, rule of give and take, applies in practice, and thinking about floodgates concerns, on the actual facts of our case, the blocks of near Bankside are very close to each other. So the bedrooms in the flats are within a few feet of bedrooms of neighbouring flats. And also on the facade of the Tate's extension facing the flats, there's not only a viewing gallery, but there's also, you may have seen from the photographs, there's 2 floors containing, I think there's a kitchen down there, and there's also a members area where members can have a coffee or have lunch. And applying Baron Bramwell's rule of give and take, obviously the claimants would have no cause of action from viewing from a bedroom of a neighbouring flat, even a few feet away, as a result of ordinary glanced or ordinary looking, as a result of their neighbours going about their ordinary business, whether hoovering or making the bed or reading the paper. And equally, from the facade of the Tate, they can't complain about someone sitting in the members area, drinking a coffee, looking out the window. There's obviously no question of complaining about that. It really is quite sort of extreme, unusual cases. It's not overlooking. It's the sort of dedicated viewing that is the issue in our case. Yes, my next point. Yesterday, my Lord Justice Lewison raised the possibility of a cause of action under the Protection of Harassment Act. And in addition to what your Lordship said about that. We also think there'll be two further problems in our case. To establish a claim under the Act, you need something that is characterisable as harassment. That's what the case is saying, characterisable as harassment. And you also need something that is harassment to a criminal standard, because the Act creates both civil liability and it's also a crime to harass under the Act. So you need something characterisable as harassment of a criminal standard, not of a criminal standard. It's got to be a type of conduct that...
Criminal seriousness.
Exactly, criminal seriousness. And certainly we carefully looked at the Act before commencing our claim and thought that for those two reasons it was a claim against the Tate would be, under the Act, would not be sustainable.
Well, that may be a point against you, it may it not, because it might be said, well, Parliament has considered what kinds of intrusions should be actionable in tort. And what it has decided is that intrusions, amongst other things, should only be actionable if they reach a criminal seriousness.
I would dispute that characterisation of what Parliament was doing in enacting that Act. It was an Act directed at stalkers in particular, albeit the Act was framed in slightly wider terms, envisaging that it would apply beyond stalkers. But it is, I would suggest, an Act directed at in what circumstances harassment would be would give rise to liability, not intrusions in general. My next point, turning to what my learned friend said this morning about the significance of Article 8.
Yes.
We say it's got the sort of significance at two levels. First of all, we agree with what my lady Justice Rose said, that at one level you've got to ask yourself, leaving aside the facts of our case, whether in order to accommodate Article 8 rights, the law of nuisance must protect privacy by dedicated viewing or overlooking in some circumstances. But also there's another level of analysis, which is if the court is of the view that on the facts of our case there has been a infringement of, or there is an infringement, a continuing infringement of the claimant's Article 8 rights, then under Section 6 of the Human Rights Act, the court has a duty to find a remedy if it can. On the facts of our case, as found by the judge, the claimant's Article 8 rights are being infringed. Your Lordships and your Ladyship will find the test to be applied in the Murray case, Divider 23 of the Bundle of Authorities. This is it's the judgment of the court delivered by the then Master of the Rolls. So just to the left of G at the foot of the page.
Sorry, which page?
Sorry, I didn't tell you. 502.
502.
So the test is to the left of G. The question is what a reasonable person of ordinary sensibilities would feel if she was placed in the same position as the claimant. Would feel about whether there was a reasonable expectation of privacy. And then I'd invite you to read paragraph 36. And the judgment refers to quite a...
That's a very different test in 36 from the test that you've been saying is the correct test for deciding whether something is a nuisance or not. And then in 37 he goes on to discuss the position of a child, which is something that we raised yesterday. So, or perhaps you're coming to it, but if you come to the conclusion that there has been a breach of Article 8 rights, there then, you say, has to be a remedy.
Yes, and
but if that remedy is then a cause of action in nuisance, how do you overlay the requirements of a cause of action in nuisance to succeed over the rather, we'll look at everything test in 35?
I mean, on the facts of our case, there is no problem. The cause of action in nuisance, without any great modification, vindicates my client's Article 8 rights.
Then what about children then?
Well, as I said yesterday, the judge rightly took into account the effect on children, because the ability of children to occupy the flats is part of the amenity.
The child's cause of action, I think let's assume for the moment that someone who doesn't have any rights to the land cannot vindicate their Article 8 rights by having a cause of action in nuisance.
Well, you say that. Yesterday...
Well, if it's not the case, then I don't see what the difference between what you're urging us and creating a new tort of breach of privacy in breach of Article 8 is.
Can I answer that by taking you to there's quite a helpful article, the Supplemental Bundle of Authorities.
Are you finished with Murray? Because I'd like to ask.
Yes, I finished with Murray.
Murray was a case where the judge struck out the claim, essentially on the ground that Article 8 wasn't engaged. What this court decided was that Article 8 was engaged. If you look at paragraph 45, it is at least arguable that David, child, had a reasonable expectation of privacy. That's stage 1 of the analysis. They never got to stage 2, which is justification.
Yes.
So simply to say that what they say in paragraph 36 is the test, I would suggest is not correct.
That is quite right.
It's half the test.
There's half the test, and there is stage 2 of Article 8, which requires that it requires a balancing.
Well, isn't that the balance? Isn't that why the judge said the balance that he carried out was pretty much the same for nuisance as it was under Article
No, the
8?
judge, when he was talking about that, wasn't talking about any balancing exercise under the second part of Article
Well,
8.
if he wasn't talking about that, then you haven't got a finding that there was a breach of Article 8.
No, but first of all, in a case like Murray, there is a real issue as to the second part of Article 8, because you're balancing the Convention rights to privacy under Article 8 with the Convention rights of freedom of speech.
Yeah.
And that's why there's a balance. In this case, there's no balance to be made.
Why not?
Well, what would you be balancing?
Why can't the Tate say that, looking at Article 8 text, which is partly set out on page 499, one of the protection of the rights and freedoms of others, and one of the freedoms the Tate has is the freedom to use its viewing gallery for the purpose for which it got planning permission and for which it's constructed.
Well, I would suggest that
Simply
the weight of
But that's for the judge, isn't it? To weigh up, to make that evaluative judgment. What I'm finding difficult is to find where the judge has said that there was a breach, or there would have been a breach of Article 8.
no, it is correct to say there's sort of two quite different points. Can I come back to that and first of all answer my Lady Justice Rose's point, which is about the sort of I am going to come on to that, the interface between Article 8 and nuisance. So I want to take you to the supplemental bundle of authorities, Article 17, which is a article about nuisance and human rights. And unhelpfully there's no paragraph or page numbering, but if I could take you to the page with starting footnote 90. 90. And this goes to the point that you just raised, and was raised by my Lord the Master of Rolls yesterday, which is whether, as a result of Article 8, there need to be some accommodation to allow individuals to bring claims of nuisance, and sort of expanding the parameters of the tort. And I, in light of what Lord Cook said in 100 Canary Wharf, I suggested there might be some sort of argument to that effect. And if you see just above halfway down the page,
Right, which page you want?
sorry, there's no page numbers, but if you try and find footnote 90,
90.
90.
Yeah, you've got the right to sue.
Exactly. So about 10 lines into that, you'll see in his dissenting opinion in Hunter, for example, Lord Cook drew upon Article 8 in support of his argument for the extension of the right to sue. Then it says, in the later case of McKenna and British Aluminium, Mr. Justice Newberger held in the strikeout proceedings that there was an arguable case that the limitation of the right to sue in nuisance to those with an interest in the land violated Article 8 rights. If I invite you to read the rest of the material under that heading, just goes over the page. But then the author deals with our situation a few pages further forward. It's the page on which footnote 112 appears. is the paragraph starting at the second additional area of nuisance law.
What's the point he's making here?
Well, that in order to give effect to Article 8, it may... Well, first of all, we think he's got it wrong by saying the law of nuisance couldn't otherwise give a cause of action for overlooking. But he suggests that if that is a rule of the common law, it might need to be modified to give effect to Article 8 rights.
This thing about landlords. Is that the footnote you referred to, 112?
Yes, but it's the passage, it's the paragraph starting at the second.
Paragraph, the second edition.
Oh, I'm so sorry, it's the next paragraph. So sorry.
So the whilst it might be a step too far to expand who can sue, the effect on Article 8 on the law of nuisance, the author says, would be hardly fundamental. But I partly rely on this just to suggest that the idea that Article 8 rights can affect the content of the law of nuisance is like, you know, it's hardly hardly a sort of radical idea. If I could turn to back to my Lord Justice Lewison's point.
We're still on Murray.
We've actually left. I don't need to go back. Don't need to. So before I again attempt to address what my Lord said, if I could take you to a reference to a case in the judgment. It's in the core bundle at page 50. Core bundle at page 50.
I was still on the same point, point 9, Article 8. You start off this point by saying Article 8 has significant two levels.
That's right. I'm
We're still on that.
We are, yes.
So which page in the judgment is it again?
So it's page 50 of the core bundle. And towards the, just below G, there's a reference to the case of Kennett and Ash. And there's a passage from the judgment of Lord Justice Buxton. And I'd invite your lordships and your ladyships to read the passage from the judgment and also paragraph 171 afterwards. And this was a case in which a friend of a folk singer had written a book which described various things relating to her home, including a decor, layout, state of cleanliness, and other things. So I rely upon the fact that Mr. Justice Eady, at first instance of that case, approved by the Court of Appeal, said that convey details to someone's home in a book without permission to the public in general is almost as objectionable as spying into the home with long-distance lens and publishing the resulting photographs, which is quite close to our case.
Is the judge's conclusion of paragraph 171 justified by that passage? The passage is concerned with publication of details.
Yes, and actual looking is worse.
Looking is worse than publishing.
Of course, it's worse in text, to describe something in text, rather than to actually engage in viewing and photographing. There's a much more extreme invasion of privacy. It'd be much...
The judgment in McKenna's and Ash was to do with publishing, whether visually or verbally, what you had observed. It's not about observing.
No.
So the judge says external prying into a home would contravene the privacy protected by Article 8. That's not what McKenna's and Ash said.
No, they're describing a lesser form of invasion of privacy. I mean, it would obviously be even worse if the readers of the book could not only read about the interior of the Sims home, but could actually see it. That would be much worse.
But you could externally pry in that way from anywhere. You could pry from the public highway or...
Yes, I mean, suppose, of course, yes, of course, suppose the house was, as millions of terraced houses around the country have a sitting room window a few feet from the pavement. Of course, it's possible for pedestrians to, with glance looks, to look into sitting rooms. But that's quite different from our case of sort of dedicated viewing. It'd be quite different if a pedestrian stood on the pavement and engaged in dedicated observation and viewing into the sitting room.
Well, if somebody did do that because perhaps of who lived there or something odd about the interior,
You're then in nuisance territory.
then the Highways Agency would be liable in nuisance.
Yeah, or the individual would. I mean, if you stood outside someone, for the reasons in our case, if you stood outside someone's on the pavement, looking into someone's sitting room window, every day you turn up there, maybe there's 6 of you, and you engage in dedicated viewing and observation into a sitting room, that is obviously unlawful.
Well, it's not private nuisance because it's not joining owners. It's not what from. That would have to be a public nuisance. It would have to be somebody congregating in a public place, causing exceptional.
But
harm
the
to someone else.
primary person liable nuisance is the person committing it. It's not the property owner.
Also, that's a private nuisance. Somebody standing on the pavement
I
in a public place.
Well, perhaps it's also a public nuisance, but I mean, perhaps we can just forget about whether
it's
it's
a private nuisance at all at the moment, I have to say. But anyway, it might be a public nuisance, but that's a different matter. Anyway,
So on this, what I say about, I mean, it is my Lord Justice Lewison is quite correct to say that the judge didn't. In fact, there is a holding that he didn't think the claimant's Article 8 rights were infringed in this case. But for the same reason we've given in relation to, we've already given, his reasons don't make sense.
so I'm slightly lost the thread here. What are we now? I've read 170 and I've read 171 of the judgment, and You rely upon 171.
I rely upon this as as a close analogy to
You see 171.
our case, particularly the reference to a description of a home being almost as bad as prying into it by.
So you're relying on McKenna and Ash.
I'm relying upon McKenna and Ash as showing that as an analogous case to our case, to establish that on the basis of my submission is on the basis of the judge's primary findings of fact, the claimants do have a reasonable expectation of privacy in this case, and we say that the evaluation of the primary facts was flawed for the same reasons for the purposes of Article 8 as we've already given.
On the judge's findings, there was a reasonable expectation of privacy.
Yes, there's an infringement of a reasonable expectation of privacy on his findings of fact. And his reasons are flawed for the purposes of Article 8 as for any other reasons. The clients have a reasonable expectation that they won't be subjected to dedicated viewing from hundreds of thousands of people, even if they have big windows. And it is irrelevant for the purposes of Article 8 as for any other reason that whether Tate is charging a fee or whether the visual offering includes something more than a flat. And I'd suggest there's no serious balancing exercise under the second part of Article 8. We're not suggesting the Tate can't have its viewing platform. We're not even suggesting it can't allow visitors to visit all of it.
Have you appealed against the judge's finding that there was no infringement of Article 8?
We haven't, but we have said that the judge was wrong in the approach he'd taken, both by applying the question, asking the question about whether the Tate was acting unreasonably, and also his approach to sensitivity. And part of the reason for that, as I've already said, is that they don't accord with Article 8 principles. And there's no serious balancing exercise under the second part of Article 8. There's no, unlike the paparazzi case, there's no countervailing convention right to be balanced. And the Tate could operate its viewing gallery and not allow visitors to view into the flat, either by cordoning off part of the viewing platform, or, as we've suggested, erecting sort of slats to allow them to look out from the southern side, but which would obscure their view. Their sort of freedom to operate their viewing platform in a way without that sort of some sort of slatted system can hardly be said to be of sufficient weight to get them home under the second part of Article 8. Just a slight one small.
Is this a new point?
Actually, no. I will continue on. Yeah, on a new point. If I could address your lordships. If I could address your lordship's point that there is no nuisance case on overlooking.
Yeah.
So
There's no case which has been successful in this country, in this jurisdiction.
there's no case that's been successful. I could refer your lordships and your ladyships to the second volume of the Authorities Bundle, the passages from Clark and Lindsell. Second volume of the Bundle of Authorities, Clark and Lindsell. Sorry, tab 28, sorry.
Yes.
The point I'd make here is that the types of circumstance that can give rise to a nuisance are very wide-ranging. And that was illustrated by the Japanese knotweed case, but it's also illustrated by many other cases. And so if I could ask you to turn to paragraph 2009 of Clark and Lindsell. So under the heading of nuisance by interference with enjoyment, the author say nuisances of this kind, causing an interference with the enjoyment of land, are, for example, creating smells by the carrying on of an offensive manufacture or otherwise, causing smoke or noxious fumes to pass on to a claimant's property, raising clouds of coal dust, making unreasonable noises. Now all that sounds quite conventional. But then, if you go on the page, using a building as a hospital for infectious diseases, whereby the adjoining owners live in perpetual dread of infection, using a house for prostitution, allowing travellers to gather to the detriment of the claimant's neighbouring property, causing crowds to collect. So, very wide circumstances. You can see from that, my learning friend's submission, that non-emanation cases of vanishing rare is wrong. Watching and besetting, as I think my learned friend said, is picketing. That was unlawful in common law, but was legalised by statute. But there is some similarity to that category of nuisance in our case. And I say that a nuisance caused by an intolerable interference with your use of land, caused by hundreds of thousands of people each year engaging in observation and dedicated viewing into your home, falls very naturally into that list. The second point your lordship raised was the 19th century cases relating to opening windows. The dicta of those cases is expressed quite narrowly, carefully. It is said that it is not a nuisance to open a window in a building to facilitate, which enables overlooking into a neighbour's property. That proposition is correct. There are two reasons why simply opening a window which overlooks a neighbour's property and then occupying the building with that window wouldn't be a nuisance. First of all, because of Baron Bramwell's give and take rule. As long as you were occupying the property normally, looking out of the window wouldn't be a nuisance. It couldn't be. Also, we think that another principle is engaged, which is that it's a principle. Hunter of Canary Wharf said that you can't establish a nuisance by virtue of the existence of a building. So we also think that it's at least arguable that that principle would be engaged. I mean, it'd be a bit odd to say, well, you can have a building, but not a building with windows. You'd have thought that sort of windows are just part and parcel of a building. So it would be open to someone to build a building with windows, even if that allowed overlooking to a neighbour. The final point your Lordship raised was whether there's any sort of compelling policy reason to not allow the use of nuisance in this situation. And so, I mean, you're sort of looking for some sort of principled policy that can be applied across the board. Now, I'd suggest there isn't a sort of serious floodgate issue, and I think part of the way of testing that is just to, if you try and sort of think of situations which would give rise to a cause of action in other cases, if this case succeeds, it is really quite difficult.
What is it that you say is encompassed by nuisance? It's got to be dedicated viewing? You seem to accept that, as it were, casual overlooking is not.
Well, and that's because of the degree of seriousness.
Right.
I wouldn't. Sorry. There's two. Well, there's two reasons why sort of casual glancing and looking wouldn't be, but part of it is to do with the degree of seriousness, and this goes back to a point I made yesterday, which is that in ordinary life, as we go about our day-to-day activities, we are quite respectful of the privacy in people's homes. We don't just generally engage in sort of gawping into people's homes, particularly if they're in there. And so it is quite rare, if you think about looking into homes generally, that you'd get anything that is sufficiently serious to be a nuisance. But also, a lot of what your Lordship's talking about, which is sort of casual looking, glancing, would be as part and parcel of the ordinary use of land, and therefore caught by Baron Bramwell's principle of give and take.
So I'm just trying to identify what it is you say brings the looking
Yeah.
nuisance.
Well,
you say it is the quantity of looking that goes on.
I wouldn't approach it quite in that way. I wouldn't approach it that way. I'd start with the proposition that nuisance, one of the things it does is to protect the amenity of land from interferences caused by the uses of land by a neighbour, and that there is no principled reason why that interference can't be caused by viewing or looking, but it would have to be sufficiently serious, and also, which would, particularly given how people generally behave respectfully towards people's homes, would be quite rare. And also, you've got the control that it would have to be something that's not caught by Baron Bramwell's give and take principle. So it would have to be something that is not part and parcel of the ordinary occupation of land. And therefore, and so just think, where the floodgates are going to open. I've given an example in the case of
It could potentially open every single case, particularly of residential property, where there's planning permission given for a balcony extension which involves overlooking.
That wouldn't. Well, first of all, I mean, the planning system, as part of the overall assessment, would take account of that. But the ordinary use of a balcony would not be a nuisance because it would fall within Baron Brownwell's principle of give and take.
Why do you say that? Well, I mean, as I gave the example yesterday of somebody gets permission to put a balcony or extension at the back of their house which overlooks the neighbour's garden, which means they're severely restricted in what they can do and where in the summer months, and it may even diminish the marketability of that house if it's to be sold, or its price. Well, that's not a figment of imagination. That's quite a practical possibility. Overlooking is one of the most common grounds for opposing planning applications, of course, in one sense, on your definition, it's a perfectly reasonable use of the land once planning permission has been granted. From the point of view of the occupier of the adjoining land, it's probably every bit as annoying as it is to your clients to be overlooked.
And certainly in that case, in terms of degree of interference, there might be a reasonably high degree of interference, but the ordinary use of a patio or terrace cannot be a nuisance because of Baron Brownwell's principle. The ordinary use of land.
But I've just given you an example, which I think you're accepting. That all the ingredients of nuisance to which you've referred would potentially be satisfied, even though there isn't dedicated viewing by thousands of people to the occupier of the land being overlooked. It's every bit, I'm suggesting to you, as annoying and a diminution in their amenity value of their land as in the case of the thousands of people from the Tate to your clients.
But there will be no nuisance case in your example because the ordinary use of a patio or terrace could not be a nuisance because of Baron Brownwell's principle. The activities that are part and parcel of the ordinary occupation of land can't be a nuisance. So that situation couldn't get off the ground. And I have, as I said, I've given examples in the.
Why do you say that? Let's go through the various ingredients you mentioned. It has to be necessary. An extension to your property, to put an extension on, can't be said to be necessary, even with you on even like a washing machine. It's not like that. So you don't even get to the issue you don't get to the stage of saying the give and take part, which is the reasonable way you conduct that necessary activity. So you're not even there. So now your cases, which I totally understand, if that's the case, you focus on the infringement of the rights of the victim, as you put it. And I'm suggesting to you that in the case I'm putting to you to test your case, I'm putting to you that in that situation where you don't fall within the necessary criteria of Baron Bramwell, and you're concentrating on the harm or diminution in the amenity value of the claimant's land. At the moment, I don't see the clear answer saying that's all part of the
I don't accept your categorisation of my case, and it's because of what you've said about the word necessary, and this is why I addressed your lordships and your ladeship on what Baron Bramwell meant by necessary in Bamford and Turley. It's not a test of strict necessity. You don't ask yourself, in order to occupy the property, is it strictly necessary? You have to do this. When you look at how...
But you're in a difficult position, Mr. Weeks. Once you start to move further and further away from something which is more than just incidental, something that you can do, you've got the Tate, which is in the middle of a very highly dedicated tourist area. It's got planning permission for a viewing gallery for views. And you're in danger of moving to the situation where it's perfectly that they have done something by putting on their balcony for tourists as an amenity value, which satisfies the test.
I mean, the idea that it is a sort of ordinary, just part and parcel of the ordinary use of land, to have a viewing gallery which is run in a way that looks directly into people's flats is just obviously wrong. But even if that was right, you'd say, well, they're not running it in a way that shows reasonable consideration for their neighbours. When you look at how Baron Bramwell's, I go back to it was not an accurate description of my case. It's why it goes to what necessary means. When you look at the examples I took you to of how it's been applied in Southwark and Tanner, all the sort of activities, it's not a test of strict necessity. You're looking at just, as I say, things that are just part and parcel of the ordinary use of land. And that's why your example of the terrace or balcony would claim a nuisance would fail, because sitting on a balcony having a glass of wine in the evening is just part and parcel of the ordinary use of a balcony.
But if I invite my friends round every Saturday afternoon to admire your garden, is that stipulated?
Exactly. If you invite your, if I'm a celebrity and you invite you charge a fee to members of the public who are interested in viewing the lives of celebrities to sit on your balcony to watch me doing my gardening, that's a nuisance, as it should be. That should be unlawful. Yeah. And the law has to provide a remedy in that situation and in our situation. They're my submissions.
Thank you very much. This was extremely grateful. We're very grateful to all counsel in this matter for arguing this case so effectively on both sides. They've both been supported by banks of people behind them, and they're also grateful to all those who've assisted them. We will consider our judgments in this matter and hand it down in due course. When you receive the judgment or judgments, please do provide corrections for grammatical and textual errors only. Agree a form of order. Any further submissions are to be in writing.